Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have an interesting case from Pennsylvania that touches on a number of subjects: medical negligence, discovery, privileges, and risk management / sentinel events. All of these things are included in this case, and it's an interesting case because of the way the court resolves it. This is from the the Pennsylvania Superior Court, which is the appellate court in Pennsylvania. It's the intermediate appellate court. It's not the Pennsylvania Supreme Court. So this case involves UPMC Pinnacle West Shore Hospital and a number of doctors and a certified registered nurse anesthetist. Basically, what they are asserting is a privilege under a statute that they say means they don't have to cooperate in discovery on a particular issue. Now, several years ago, the Joint Commission on the Accreditation of Healthcare Organizations came out with a policy regarding sentinel events. And sentinel events are things that are screwed up so bad that they jeopardize life and health and safety. And as a result of that, there is an obligation under the Joint Commission rules to report things that fall in as sentinel events. Well, in Pennsylvania, they have adopted something similar by statute. So what's the case all about? Well, the hospital appeals from an order that granted Jane Betts's motion directing the hospital to take reasonable efforts to identify the author of an anonymous report concerning the care and death of Richard M. Betts, the decedent at the hospital. That was her husband. Specifically, the hospital contends the trial court erred in doing so because ascertaining the identity of the reporter would violate the whistleblower protections of the Medical Care Availability and Reduction of Error Act, MCARE Act. We find no error in the trial court's interpretation and application of the pertinent statutes, and we affirm. Since the issue in this appeal is collateral to the plaintiff's claims against the hospital and individuals who provided care, we need not recount the facts of the underlying action in detail. Briefly, decedent died following elective knee surgery performed at the hospital in June of 2020. The plaintiff filed a complaint stating wrongful death and survival claims alleging that defendant's negligence caused decedent's death. Defendants denied that their treatment deviated from the standard of care or that they caused decedent's death. During the course of discovery, the hospital produced 4 incident reports made in connection with the decedent's treatment. Pertinent to this appeal, Event Report EV 2020-179-8812, the anonymous report had been submitted anonymously through the hospital's online portal in accordance with its MCARE Act patient safety plan. Let's talk about anonymous reporting for a moment. Just like it would be in any big organization, office politics plays a dominating role in the healthcare organization too. You have hospital administrators and doctors who sit sort of at the top of the pyramid. You have nursing managers and department managers under that. You have the staff underneath that. And just because someone is on the same level with you, perhaps a floor nurse or an ICU nurse, and they are at the same level with you, that doesn't mean they won't come gunning for you if they think that you blew the whistle on them. And that's especially important when you consider a very serious allegation like medical negligence, particularly in a wrongful death claim, because the wrongful death claim It essentially asserts that your negligence killed somebody, which could get your license yanked by the state. Hey, allow me to interrupt for just a second and ask you, if you haven't already subscribed, please subscribe. And if you wouldn't mind, hit that like button. That lets YouTube know that this is a good video and they can recommend it to others. It helps me out a lot. Thanks. Well, here is what the incident report said. Patient was given 6 half milligram of hydromorphone and 4 milligrams of morphine post-op in the post-anesthesia care unit. Based on chart documentation, the patient was desaturating. They say desatting, but it's desaturating, meaning that his oxygen concentration levels were dropping. Usually on room air, your oxygen concentration will be between if you're normal and healthy, between 98 to 95%. A little bit less if you're a smoker because you're going to have some carboxyhemoglobin in there. But you can tell how well a person's ventilating or at least oxygenating based on the saturation. Now, this anonymous reporter, says that the narcotics required them to use 3 liters of oxygen by nasal cannula. The patient was then transferred from the post-anesthesia care unit to WS4, which is probably a Ward South 4, so probably on the 4th floor of the hospital in the south wing, without any bedside handoff to the floor RN. And by bedside handoff, what I mean is when a patient is transferred from a unit to a floor, normally the nurse transporting the patient up to the room will meet with the nurse who is receiving the patient to care for, and she will tell that person what's going on. Hey, this is Mr. Betts. He had knee surgery, came through it fine. We've given him some morphine and some hydromorphone for pain. He seems to be doing okay as far as the pain goes, but we're a little concerned about his ventilation. You might want to watch that in the post-operative period. And I don't think I have anything else to report to you. Whatever they needed to tell them so that they could, do decent care. There wasn't any bedside handoff, though, or no report given, so the floor RN found the patient unresponsive and pulseless, and a code blue was activated. Well, anytime somebody has enough morphine in them to cause them to quit breathing, they had way too much morphine. And that's what happened here. He essentially was feeling so good from that morphine that he just quit breathing. I had fentanyl after surgery once, a fairly painful surgery, so they gave me fentanyl. And my oxygen saturations went down to like 85% because I was feeling so good. It was like, why would I ever care if I breathed again? That stuff really messes with your head, and that's what happened here. It messed with his head. He suffered an anoxic brain injury due to cardiac arrest. And then because he was basically going to be in a permanent vegetative state, they withdrew care and he died during the admission. So this was submitted through the patient portal anonymously. And the reason that caregivers do that is to avoid someone, my guess is this was probably done by the floor nurse who felt like she'd been improperly handed off a patient by the PACU nurse. It might have been done by one of the people who was on the transport team. It's hard to tell who did this, but somebody made this report, and they did it anonymously because they didn't want to deal with the flack from the people who are implicated in this event. And this is more than just an incident. This is really a sentinel event, and it's a bad thing. So in the course of filing this lawsuit, the plaintiff wanted to depose the authors of all 4 reports. Well, 3 of the authors were named because the incident reports were written out and signed, but this one was not. It was anonymous. And the hospital said, well, we're not going to reveal that because it was submitted through this MCARE Act portal, and because it was submitted through that portal, it's privileged. Well, we're going to find out that probably overstates the case. And it's important to remember here that this is something that is reasonably rare in litigation. It's what we call an interlocutory appeal. Essentially, if you have a trial court make an error, they make an error in the admission of evidence or whatever, that's something that gets resolved at the end of the case in the final appeal of the case. This is a situation where they're complaining that their privilege will be destroyed if they turn over this information, and they don't want to do that, so they are allowed to get an interlocutory appeal based on the rules in Pennsylvania. So plaintiff moved to compel the deposition, and there was a hearing before a discovery master. The hospital said that the identity of the anonymous report was unknown at the time, yet it was not represented that such information could not be extracted from the hospital's reporting system. Ultimately, the trial court entered an order granting relief recommended by the discovery master. They said the motions granted to the extent the hospital is directed to perform reasonable search of the system utilized by the author with a view toward determining the identity of the reporter and to serve a verified report of the result of that search on plaintiff's counsel within 45 days of the date of this order. And so the hospital timely appealed, and the question is whether the trial court erred in concluding the whistleblower protections of Section 308 of the MCARE Act did not protect the anonymity of the author of the confidential serious event report. And again, in Pennsylvania, you have serious events, which are like sentinel events under the JCHO protocol, and you have incidents. Incidents are just bad things, but they don't involve serious injury or death to a patient. So the court begins with the general principles that whether materials are privileged is a question of law. Where there is a statutory interpretation, it's a question of law. So the review here is de novo. In other words, it looks at it fresh. It doesn't consider the decision of the trial court. It simply makes a finding on the basis of what the law is. It then notes that the object of interpretation and construction of statutes is to ascertain and effectuate the intent of the General Assembly, and that the plain language of the statute is the best indication of that. Evidentiary privileges are disfavored, and they are used only to the limited extent that excluding relevant evidence has a public good that transcends the normally predominant principle of utilizing all rational means for ascertaining the truth. The party invoking a privilege must initially set forth facts showing that the privilege was properly invoked. So going down here, they say the instant appeal is the hospital's claim that the identity of the author is privileged from discovery based upon the whistleblower law incorporated by reference into the MCARE Act. So then the court does essentially what the trial court did, is it looked first of all at the MCARE Act, and this is the MCARE Act, and it says a healthcare worker shall report serious events or incidents. In other words, through the patient safety plan, they have an obligation to make these reports. And a healthcare worker who does this is protected from retaliatory action. And if they do this in good faith and they make a true report, then they have nothing to worry about. But the limitation is if they make a false report, they can be disciplined. So the Act guarantees freedom from retaliation and the protections and remedies offered by the whistleblower law. Well, the whistleblower law was designed to enhance the openness in government and compel the government's compliance with law by protecting those who inform authorities of wrongdoing. And so it talks about persons not to be discharged, and it says an appropriate authority to which a violation of this act was reported may not disclose the identity of a whistleblower without the whistleblower's consent unless disclosure is unavoidable in the investigation of the alleged violation. They say the law was intended to discourage retaliation by the target of the whistleblower's report, and the agency is restricted in its right to disclose the identity of the reporter. The law does not purport to preclude the target itself from ascertaining the reporter's identity by other means. The trial court opined that it would be absurd to allow the target of a whistleblower to use the statute as a shield against discovery of wrongdoing, because that's what the statute's there for. It's there to promote the discovery of wrongdoing. So the hospital comes in and says, look, the trial court's reading renders the MCARE Act's reference to whistleblower law superfluous, or, as they might say in some of the more rural areas of Missouri, superfluous. Anyway, the hospital posits that the anonymity protections of the whistleblower law, man, did I have trouble with that word, anonymity, do not merely protect the employee from adverse actions by the employer, but also ensures the whistleblower will not face collateral damage professionally and socially, will avoid retribution from the target's associates, and will escape attack from third parties who are negatively impacted by the report. And if you read that, basically what it means is the hospital is saying that there's all kinds of people just waiting to pounce on this person who made this anonymous report and beat them to a pulp because they blew the whistle on them, which I think sort of grievously overstates the case here. Yeah, they'd probably be browned off at him for a while, but I don't think any serious harm is going to come to somebody in a hospital who acts as a patient advocate. All nurses are patient advocates. All respiratory therapists are patient advocates. Their job is to protect the patients at all costs. Yes, sometimes even from the doctors. Therefore, continuing the investigation in this case does not make the disclosure of the anonymous report unavoidable. The hospital maintains that it's precluded from disclosing the identity of the anonymous reporter absent that individual's consent. So in trying to answer this question, the court goes down and it says that while employers may not terminate or otherwise discriminate against an employee who made a good faith report, the anonymity provision of the law makes no reference to employers, constraining only the appropriate authority from disclosing the identity of the employee. Therefore, we must determine whether the hospital stands in the shoes of an employer or an appropriate authority for purposes of the Whistleblowers Incorporation of the MCARE Act. The term appropriate authority is defined in the statute as a federal, state, or local governmental body or the individuals who are working in that governmental body. And it says our review of the pertinent provisions leads us to the ready conclusion that the hospital is not an appropriate authority prohibited from disclosing the identity of the author of the anonymous report. They note that the medical facilities are required to develop and implement patient safety plans that, among other things, establish a system for healthcare workers to report serious events and incidents to a patient safety officer who's tasked with ensuring the investigation of the reports and, in turn, reporting them to a patient safety committee. That committee then makes recommendations to eliminate future serious events and incidents. And to oversee that system, the legislature established the Patient Safety Authority. We deem it no coincidence that the MCARE Act, as detailed above, contains no reference to anonymous reporting, but does allow for anonymous reporting to the authority after the internal report is made. In sum, we hold that 40 PS 1303.308 does not preclude the hospital from taking reasonable efforts to ascertain and disclose to the plaintiff the author of the anonymous report. Therefore, we have no cause to disturb the trial court's order. So I think that's a really good rule. And the good rule being, if you can get the information, you need to turn it over, because there is no purpose in keeping that individual's identity secret simply because, frankly, they're the person who may be in the best shape to tell the court and the jury exactly what happened based on the language that they used in their anonymous report. So that makes the system work better and it achieves a more just result. That's what I have for you today. I want to thank you for watching. If you have the opportunity today, go out and do something nice for somebody, and then come back and join me tomorrow down here at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.